Welcome back to this week's episode of The Emily Show. Today, we are taking a look at the May 2nd hearing in Idaho. So for those of you that listen on audio app, you will hear parts of that court hearing and me talking about parts of that court hearing. What are we in court to decide today in Idaho? The state is seeking to seal a number of upcoming hearings on motions to compel. The defense is saying that this state is not turning over information, and some of that information was relied on in the probable cause affidavit, and the state is required to turn it over. The state is arguing that they have turned over what they have. Some things they aren't required to turn over, and some things they are fighting with the FBI to get, and they need the court to sign subpoenas to do that. So we are going to go through that hearing. I have clipped out the relevant parts of argument from the prosecution, the defense, and the court's rulings. If you want to see the full hearing without commentary will be linked down below. We saved that on our Law & Order TV channel so you can watch it. And the hearing, as I recorded this episode with commentary, is available for the members. So let's get into today's episode. Welcome to The Emily Show. I'm Emily D. Baker, the internet's go-to legal analyst and big fan of the cursey words. I've been a licensed attorney for over 17 years. I'm a former prosecutor, and I break down the legal side of pop culture and entertainment stories we can't stop talking about. We should just get into it. Let's go. Boy, do I know that life gets busy, and today's sponsor Factor helps with that because sometimes there isn't time to cook, and you still want to have a delicious, easy, ready in just a few minutes delivered to your door meal, but you don't really want a frozen dinner. And that's where Factor's fresh, never frozen meals are perfect. They are dietitian approved, and they are nutritious and great tasting. And you can pick from any type of eating style you prefer, from keto and protein plus to vegan, vegetarian, or just balanced chef choice meals. And meals include premium ingredients like filet mignon, shrimp, and blackened salmon, which are the ones Dr. B always takes out of the refrigerator first. So when life is busy and you don't have time for meal prepping, grocery shopping, and maybe you just don't want things to go bad in your fridge, Factor is a great option. You can also pick breakfast and desserts because some days you just don't have time and still want to eat well. And of course, I've got an offer for you as an Emily Show listener. Head to factormeals.com/EDB50 and use code EDB50 to get 50% off your first box plus 20% off your next month. That's code EDB50 at factormeals.com/EDB50 to get 50% off your first box and 20% off your next month while your subscription is active. Let's get back to today's show. All right, we are going to court in Idaho for the Bryan Kohberger hearing from May 2nd.
First thing I want to talk about is whether or not this hearing should be sealed. What's your position, Ms. Taylor?
Your Honor, this hearing should not be sealed.
Okay. Mr. Thompson?
Your Honor, the state's prepared to do its argument today without actually talking about the specific request that we're trying to protect within the discovery request. And so as long as those specifics are not discussed or mentioned, then I think we can go forward with an open hearing today.
Okay. Are you comfortable with that, Ms. Taylor?
Well, what I'm not going to talk about is the content of the court's protected materials that we've asked for a sealed hearing for. What I'm prepared to talk about is why should we seal this particular motion to compel that's set to be heard, and how much else is in the public record and why there's no compelling reason to seal that, and why that violates Mr. Kohberger's constitutional rights. So if I talk about things that are in the affidavit, and if I talk about things that we're seeking that the state wants to hide, I think that's fair game for the public to hear.
Strong words with if we are seeking things that the state wants to hide. Oh boy. Well, we will see what Ian Taylor wants from the state, but keep in mind, the defense has been filing motions to compel aspects of discovery for well over a year.
The challenge here is that both sides have agreed to seal all the discovery. There's a lot of stuff out there, and so I just want, I hope that you can both honor that at this point, because down the line, I mean, maybe some things do have to discuss, we need to discuss very specifically that maybe both sides don't want that out in the public. Because it is a fair trial goal here. And if we start arguing about the case itself, the trial, and the evidence that you're gonna present, both sides, gets more complicated and may be prejudicial to one or the other. So I guess at this point, we'll keep this open, but be careful. I mean, I've read everything, so I know what's sort of out there and what you're concerned about. And some of those materials or potential evidence could be prejudicial to the state, or it could be prejudicial to Mr. Kohberger. So my job is to try to keep on a balance here, a neutral balance, where when we get to the trial, if we ever get there, that it'll be fair and will have been determined in advance.
It's never good when the judge is saying, if we ever get there. But I do appreciate that he is reminding both sides that there can be prejudice both to the state and to the defendant. Generally, the worry and the concern is much more about potential prejudice to the defendant. But at this point, they're going to keep this hearing open, though some future hearings, as we will talk about later, are not going to be open.
Okay, so keep it open today. If something comes up and we need to close it down for a period of time to discuss a particular situation, then we can do that. Okay, so it really, I think at this point, it's the state's motion to close the hearing completely on May 14th. I believe, I'm not incorrect, that you both have stipulated to closing May 16th, which is related to the IGP.
Your Honor, our position is that's the only part that should be closed, and that's because we want to talk about the content of the materials protected by the court's order. And so that one's appropriate to close.
Okay, I think I'm on the same page, but great. Okay, Ms. Jennings.
The prosecution is arguing for the discovery hearings on the defense's motion to compel to be sealed.
If the court decides to open this hearing to the public, the state defense will be discussing evidence without any context. This will undoubtedly fuel speculation, lead to assumptions, and false narratives. The evidence discussed may not even be offered, and most of it likely will not be offered by either party at trial because it's either not relevant or material. The public will not have any means or context to be able to differentiate that. It is necessary to mitigate this by closing the hearing in order to preserve the right to a fair trial for both parties.
Interesting to me that the prosecution seems very concerned, and they've already addressed privacy rights, but very concerned that if this is an open hearing, then the public might get the wrong impression or narrative. But isn't transparency something that we're looking for in court? And what wrong narrative are we talking about? What is going to come out in these motions to compel? And keep in mind, discovery isn't always stuff that will come in at trial. Not everything will be relevant. Not everything will be admissible. That's a fair argument, but we don't want the public to have this information without context. And it is the state asking to seal these hearings. What information without context are they worried about? I wonder if we'll find out as we get into this hearing more.
The defendant does have a right to a public trial, but that does not mean the right to try this case in the media.
The defendant will get his day in court, and the public will have a right to see what evidence the state has. But that should be evidence that is admissible pursuant to the Idaho Rules of Evidence. Now is not the time for that. We ask the court to grant the state's motion to close the hearing regarding the defendant's fourth and fifth motion to compel discovery.
The prosecution wants this case not tried in the media. They are worried about, it seems, whatever information might come out being things that aren't going to come up in trial. We know that the fifth motion to compel is regarding the IgG data, but we don't know all of what this fourth motion to compel is about.
Our discovery requests have been filed for months, and they've gone unanswered too. So if we want to talk about being on notice for something, we can talk about that.
She's not wrong.
Can I just add, because I've read through all of the fourth and fifth, and it's, I mean, some of the information it seems anyway. I mean, it's hard to know.
Is Judge a little speechless? Like, Ann Taylor came in hot, and it sounds like he is trying to reset the room a little bit, but she's not wrong. Some of these discovery motions have been outstanding for a year. It's not as if we're new at asking for this, but it seems that Judge is a bit speechless. I imagine that Ann Taylor is deeply frustrated by how long some of these discovery requests have gone unanswered.
Okay, but it seems like the state has provided and has responded to some of those requests.
Some is
and
not
some,
all.
they're still waiting to get that information. So that's the impression I had. I don't know if you disagree with that or not.
Well, I'm glad, Judge, that that's the impression that you get. But this case was charged in 2022. I mean, it was the end of 2022, but it was 2022. So if the state does not have all the discovery in May of 2024, then the state needs to start getting court orders to force things to be turned over. Because if law enforcement is not complying with the state's requests, then there needs to be an escalation of that.
I would say the court is maybe in part right, but there's a lot of other parts to those fourth and fifth, and the court's referring to our motions to compel, not discovery requests themselves, but they do reference a number of discovery requests that have been going out. And we can talk specifically about each of those items.
I prefer not to.
And which is fine.
I bet you do.
I'm prepared to talk about why this needs to not be a closed proceeding today.
That's the point
But
today.
I don't agree that the state is completely responsive here. So I think the court can read and see that they say, we'll get it when you get it. I think the court can read and see when they say, we're not going to offer it, so we're not going to get it. I think the court can read all of those things, and we'll talk in depth on the 14th about what they mean.
Ann Taylor is arguing to the court that it is the defendant's Sixth Amendment right that governs here, that the defendant's right to an open hearing and a public trial under the Sixth Amendment and the Idaho Constitution is what the court needs to consider, and not what, as she says, the state is trying to hide. So she is starting to argue with the court about what needs to be considered under the law to seal this hearing, because she is arguing the default is that this hearing stays open, not sealed as the state is asking for.
Been a pattern to do things in the public, and now this one needs to be sealed. The court has to ask itself why. And the court should ask itself, what is the state trying to hide here? The things that we're seeking in these motions to compel are things that are outlined in the probable cause affidavit that has been public for a year and a half now.
Yeah,
that has been offered to be shared far and wide.
Oh,
we're looking for things.
Look at Ann Taylor calling it back to the hearing with the expert regarding the motion to change venue. Remember, when the expert was on the stand, he was talking about the press conference that the prosecution did that really said, the prosecutor stood there and said, this is the probable cause affidavit. This is what can be shared. This is the facts on this case. And this was right before this case went into the non-dissemination order lockdown. So the prosecution, it seems from the defense's perspective, got their perspective out there. And the defense has been under the non-dissemination order. In addition to that, if the defense is saying that there is information in the probable cause affidavit that they still don't have, that's wild to me, because that's what they based their PC to arrest the defendant on in December 2022. So why are the things in the PCA not turned over yet? I'm very interested to see where this goes from Ann Taylor.
Videos that the state said they collected so that we don't look at things in a little vacuum. The state tells you not to take it out of context. That's what they're doing when they want us to do this in private and not let the state know about the full scope of the videos that are out there that they haven't given us. That is the state keeping things in a vacuum to control the public narrative. And that violates Mr. Kohberger's rights. That's what we want to prevent. This needs to be out in the open. Your Honor, I'll give you a couple of examples. The state filed last June its motion for protective order of the IGG materials. That motion was filed in public. It's on the public record. People can print that and read that and do all day long. And that had information that was negative about Mr. Kohberger in it. So that's out there in the public. But that order was to protect information, the IGG information, that they say details how the state got to Bryan in the first place. That's been sealed, that's fine, we respect that. But you have to question, why can we not talk about the things they're not giving us? Why can we not talk about the cell phone information, the tower information, the drive test information in a public arena? Why should Bryan have to have his case, when he's asking for this information, be done in a little vacuum? Where the state says what the public can hear and what the public can't hear.
Cell phone information generally doesn't get sealed and doesn't need to be sealed. It shouldn't impart anyone else. Maybe it does, but on the motion to compel, you don't need to get into all of that, because the cell phone data seems to be a central part of the state's case. And the defense is making a good argument. You need to ask yourself, Judge, why doesn't the state want these conversations about the information that they have not turned over yet to be discussed in public?
Example of this, Your Honor, is with the video tape that they've relied a lot on in their probable cause affidavit that we've received different parts of. Part of the hearing on the 14th is to talk about the different parts of that video that we've received and how we need the whole context. This is the video that they say places this car near the residence. We've received little tiny pieces of that.
What?
And we think Bryan's right to a fair trial means the public needs to know that they've withheld the audio from a great portion of that, and that it starts a long time before the little clip that we've received.
What? How are 51 terabytes of data have been turned over on this case, and you're telling me they don't have the entirety of the video and the audio from the video that covers how the probable cause affidavit says that they saw the defendant's car going towards the crime scene? You can't edit the video. Yes, it might all not be relevant at trial, but it could include exculpatory information, which you are required to turn over. What is in the 51 terabytes if the state's only turning over clips of the video? Clips is not what's required. Wow.
To do this in a vacuum, Judge, When documents are filed under seal, that's fine. Those are documents, but this hearing needs to be in the public eye. For the court to allow the prosecutor to say, we need to keep this all private for a fair trial, really ignores the public nature of this case. It really ignores the fact that Bryan has been essentially convicted in the media. You don't have to read but a few articles to see how negative they are about him. He has a right to have this information withheld, brought out in public, so that people can see it's not this neat little package. So people can start to wonder if Bryan's innocent. Your Honor, Bryan is innocent. And he has an absolute Sixth Amendment right to have his hearings in public. We think if the court allows the state to shield the information and how they got their information and what they don't want us to have from the public, they're using his Sixth Amendment rights to hide behind. And that's just not what the court should allow. We strongly object to these kinds of things being closed.
That is a strong argument for Ann Taylor against the state having the hearing on the motion to compel sealed. And Ann Taylor made the point. The initial motions to compel, not the discovery request, they request the discovery, the court orders the discovery, they don't get the discovery, and then they move to compel the discovery because they're like, I was supposed to get it. Where is it? Ann Taylor is arguing, look, we've had other motions to compel filed publicly. This hearing should be public. And the state's right is not to a narrative or protection of that narrative. That's not what these rights are for, and that's not where you seal a hearing. What Ann Taylor didn't argue, because of course her interests are the rights of her client, but that the public also has a right to public hearings. The public also has a right to see what's going on in courts. The press has a right to be present in court. It was fought about a lot in this case about the public's right to access. Our court system is not built to do things behind closed doors. It's built for everything to be public and then to seal only what is absolutely necessary and to take the least restrictive means possible when sealing things from the public. I agree with Ann Taylor that personal information, private data, things that concern privacy should be sealed in this case. They should. And she's not arguing about documents being sealed. She's not arguing about the IGG data that might turn over other people that aren't ever going to be connected to this trial. It might turn over their information, and the public sometimes is going to public, and those individuals should be protected from that. She agrees. The state agrees. I also agree for what it's worth. But part of what it sounds like she's arguing about in this motion to compel is the entirety of the videos relied on in the probable cause affidavit not being turned over. And I got a big problem with that. She's also saying, Your Honor, Bryan is innocent. Look, Bryan is innocent until proven guilty. So she is allowed to argue that in court all day long. Sealing the hearings don't give transparency to a contentious case, any case. And I imagine it doesn't sit well with the victims' families that they are also being kept in the dark.
You know, I don't know where did it stop though. I mean, if we start pulling out all the potential evidence for the trial before the trial, then does the state get to respond to that? And that's where does it start? I mean, it or stop? It just is a roll of that, and so either
that's how cases work.
Either side, okay, that it sends to the public that it is not. You don't get the context. They don't have the context. The public, you have the context. You want more context. I get that, but it's really difficult to just open that up and talk about particular issues in the case without talking about the entirety of the case. And that's what trials are for. I mean, I totally understand that Mr. Kohberger has a constitutional right to a public trial. But having a hearing is not a trial. That's something different. And so that's why, that's where the balancing comes to, if you want to answer that.
But Your Honor, the public not having all the context isn't really the point, though.
The Waller versus Georgia case is in the context of a motion to suppress. If the court starts closing hearings now, when the court hasn't closed the other motions to compel, what's the court going to do when it comes time for a motion to suppress? Those are coming. Many of them are coming. We want the hearings in public. The state has dropped bits of information with different filings they've made all throughout the way. This can't be done in private. It just can't.
I would say both sides have said in their motions or in their briefs that they've disclosed, certain things. And
He's pushing back on her argument that the
it's a
state's
change. See that
dropping breadcrumbs.
because both sides have agreed to seal a lot of these issues of evidence in the discovery. And so all of a sudden it just does feel like it's moving in a different direction. But I understand what you said. It's like, this isn't about discovery. This is about the hearing.
It's interesting to me that Judge is pushing back on, well, if we just make it open, where does it stop? Well, in most cases, everything is just open except for a few documents that are filed under seal. Like that's how it goes. Most things are just open. And the pretrial motions are open. The motions in limine are argued in public. And guess what? Sometimes the things argued in the motions in limine are things that don't come in the trial, which is why you do voir dire of jurors to see how much they know about a case. Because if they've watched everything, they can't be on the jury because they know things that might not come in at trial. But how can anyone evaluate a case or watch it open and publicly if all those decisions are made behind closed doors? Because then by the time you get to the trial, you don't know what's kept out. Funny enough, Dr. B was listening to a podcast, not this one at the moment, but listening to a podcast and came home and was like, hey, I heard the founder of Thrive Causemetics on this podcast and I was fascinated by the story. He's like, are those the aqua boxes that I always see at the house? And I said, yes, Dr. B, same with Thrive Causemetics. I, for one, was just thrilled that he remembered that Thrive Causemetics is one of our longtime sponsors and was heartened to hear the story and the dedication behind Thrive. There's a reason cosmetics is in the name. It's because they give back a portion of every purchase to their more than 300 giving partners. I use the Brilliant Eye Brightener every single day instead of eyeshadow. It is easy to go on. It is basically crayon makeup. The faster, the better, because I am always running late for stream and literally everything else. So I like makeup that makes it simple, but it also washes off clean. So I don't have to use any kind of eye makeup remover or anything like that to just wash my face at the end of the night, which again, makes it easy. And if you are ready to try it for yourself, of course I have a discount for you. Head over to thrivecausemetics.com/lawnerd to discover luxury beauty that gives back. That's Thrive Causemetics, CAUSEMETICS.com/lawnerd for 10% off your first order. Let's get back to today's episode. And the state now has an opportunity to respond to the defense, saying essentially, we don't have all the discovery. Everyone's trying to push this to trial by maybe March of 2025. And we can't do that if we don't have all of the discovery.
Ms. Jennings?
Yes, Your Honor. Ms. Taylor's argument and multiple completely false narratives are the exact reason why this hearing should be closed.
I guess false narrative is the word of the day in court. I don't think I've heard the prosecutor say Miss Taylor's false narrative is exactly the reason that this hearing should be sealed.
Yes, defense has a right to a public trial, but that is not the right to having all hearings open to the public. The court's right. There will be a day for this, and that is the trial. but we shouldn't be discussing all the evidence that we're going to hear at trial prior to that. There's no right to try this case in the media.
Ma'am, there's a difference between trying the case in the media and the public having the right to access and transparency in the courts, and the right for things not to be done behind closed doors. Even if you don't like the defense's position on the case, the least restrictive means are not necessarily having the hearing sealed and completely inaccessible to the public. Because if it's all sealed, the public doesn't know what hasn't been turned over. The public doesn't know what's being compelled. The public doesn't know why it's not being turned over. And if the hearings get sealed as well, then there is no transparency at all. Even if the specifics in the documents are sealed, the hearing can talk around those specifics and not give individuals names. And you can argue motions without that.
The case law that the defense relies upon has not extended this balancing test to these types of hearings.
Interesting.
The hearings are about, or the cases are about trial. And yes, they extended it to a suppression hearing, which was so interrelated to the trial.
After the prosecution argued again why they believe the hearing should be sealed, Ann Taylor has the opportunity to respond and started talking to the judge about the fact that there are particulars in the motions to compel that don't need to be discussed and addressed at the hearing. Business names, the names of individuals, but that it is less restrictive to talk about it more broadly. Why hasn't the prosecution turned over videos? Why haven't they turned over drive test information? Why haven't they turned over cell tower information? And arguing about compelling those things don't need to get into the detailed specifics that may be properly sealed, but should more broadly be available at a public hearing. She also talked about the fact that the hearing to turn over the IGG information, which is all sealed, was also public. And as she's talking about that, Judge cuts her off.
Talk a ton about the cell phone information, the cell tower information, and the things that they have not given us, the drive test information, the verification of stuff.
That's the thing. I don't want to talk about those particularly. And
did somebody say shush? Wait. As I was looking at this, I don't know if Judge cut off Ann Taylor or if it was the prosecution, because the prosecution speaks up and it sounds like she either says shush or judge. I don't know if this will come up later in the hearing, but you can see Ann Taylor look at the prosecutor and then you see Judge respond. But the prosecution is the one who interrupted what Ann Taylor was saying, not the judge. But I can't tell if the prosecutor says shush or judge. You can judge that for yourself. But either way, I'm surprised that the state jumped in. It seems that Ann Taylor was starting to tread the ground that they exactly want her not to be treading in a public hearing.
The cell tower information and the things that they have not given us, the drive test information, the verification of stuff.
that's the thing. I don't want to talk about those particularly. And I guess I'm reminded, okay, in your comment about the IGG, because once again,
Wow.
I'm in this position where I have to make decisions blindly to some degree.
I mean,
that's what
motions.
The case with the IGG. I mean, I had to go through all of that information, and then I provided most of the information to you,
Describing being a judge.
to the defense, so that you could evaluate that.
Yeah, they get discovery.
I feel that
This isn't
the
new.
same way about there's a lot of stuff, okay, that you're arguing about and the state is arguing about. And I think it's complicated to just open that up. I think that, maybe we could go through a closed hearing and then open up what you feel needs to be opened up. But I can't make that decision in the abstract.
It's not abstract, Judge. You have all of their motions that are under sealed. It is not abstract. The defense gets discovery. Most everything. There are very few things that the defense does not get. This is not new in criminal law, and you're not in the dark. You have all of the motions. It is the job of the lawyers to tell you what they're arguing over. And then it is your job to make a decision based on that information or ask them for more information. That's all. But it sounds like he's going to seal his hearing from that statement.
So that's my worry, because I went through all this last night again, and I thought, how do we really fairly deal with each one of those issues? There are a lot of issues.
I agree with you. There are a lot of issues, Your Honor. I would ask you to look at the probable cause affidavit and read the parts where they talk about relying on FBI agents and the cast report and different cell tower data. Your Honor, that stuff's in the public eye. Why can't I talk about what they refuse to give me in the public eye?
Well, one of the things that we want to talk about today is I just got motions for subpoenas, Deuces Taken, to.
Why are you changing the topic, Your Honor? Why are we switching gears? Why are we switching gears? She's talking about the fact that she doesn't have the cell tower information that's relied on in the probable cause affidavit that's from 2022. I would also like to know why she doesn't have it. She should have it. The cell tower information seems to be a large part of the state's case based on what is publicly available.
To the FBI. I mean, it's really difficult to get information from the FBI. You know that. They know that. I know that. We have we have to jump through hoops to get particular information from the FBI. That is not the state's issue, although maybe it should have happened 6 months ago.
That's the state's issue.
I understand that. But that is one of the things that, I mean, we can maybe address that today too. I don't think, thinking that you don't have an objection for me to sign the subpoenas.
No, Your Honor, I don't have an objection for the court to sign the subpoenas to try to get the information.
So I can sign that. I can sign that today.
You can sign that. You can sign that. Anything you need to sign to get us the things we want, please sign.
I'm with you. I'm trying to do that, and from what I've seen, I mean, I think the state is trying to do that. I know that it's not satisfactory from your position, but there's a lot of issues in this case.
And Your Honor, that's really a lot of what we're going to talk about on the 14th.
There shouldn't be that
is the timing of these things,
right.
Not the full content of what we think these things might show. We don't know. We don't have them. They know.
Likewise.
So I think the timing is important. Your Honor knows how much pressure there is to get this case to trial, and Your Honor also is aware of all the things that we have to do. And when we make a request and months later you're asked to sign the order so that maybe we can finally get that information, that timing part is important for the public to know. That's not the content. I'm not going to talk about the content of that subpoena you just brought.
I think it's important for the public to know, because the public does accuse the defense of dragging their feet. The public does accuse Ann Taylor, and I think she's trying to defend a bit of herself here. The public does accuse Ann Taylor of slowing down the trial, of slowing down this case, of not moving it towards trial. And she's pointing out, it's not me. I'm not the one slowing it down. You have to give me the information to do my job. This trial is going to get pushed if she doesn't have it. They can't force her to go to trial if she's not ready. This is going to get pushed if she does not get this information. And it sounds like what's holding them up is, in fact, the FBI.
Brought up. I don't need to talk about that at all. But I can talk about the delay in this and why there's a delay in us being ready for trial. That is fair game for the public.
Yep.
And that is something Bryan has an interest in having public. So I don't have to talk about that content. That's not the issue at all. But the things that are laid out in the probable cause affidavit that has been on the court's public website for 1.5 years now, it makes no sense that I can't ask for those things in the public when they're things that the state said they relied on. That just makes no sense. I have one more ask when we're done with this issue.
Okay, thank you.
Defense attorney Ann Taylor and the court have been going back and forth about information that has not been turned over, whether the defense can argue this at an open hearing without the details being disclosed to the public. And it's become clear that part of what the court is doing now is signing subpoenas for information from the FBI. And the court has said, look, if the FBI is not turning stuff over to the state, that's not on the state. Maybe they should have asked for these subpoenas earlier, to which it seems the defense vehemently agrees, because when it became clear that the FBI was not being forthcoming with information that the state was relying on, that the court should intercede and provide that information. The state again asked for that hearing over this motion to compel to be sealed. The defense wants the court to give an answer at this hearing and wants the court to leave the hearing open. Let's see what Judge decides.
I don't agree any part of the hearing should be closed, and I think you should make the decision now. We're 2 weeks away from this hearing.
True.
Oh, 2 weeks, is that right?
Hearing set for May 14th.
We're less than 2 weeks. We're 12 days.
All right, well, I kind of mentioned this a moment ago. I just feel like we need to get into the details, okay, of all these issues before I open it up. So I'm going to close that hearing.
So both
Now, that
of
doesn't
the
mean that
motion to compel hearings will be closed.
after we sort out all of those issues and I have more understanding of why you aren't getting what you want or what you asked for, or whether or not there is something that you've asked for that doesn't exist, or that some of the materials are holding with the FBI and that we need to get that. I mean, those are all really complicated processes. And I would feel much more comfortable when, again, I'm trying to protect a fair public trial and not have a maybe not intentional, unfair hearing, okay, that goes out to the public. I think that's the balance for me.
He's always been real cautious about what's in the public eye.
What all the issues are, the arguments from both sides, so that I can make a more informed decision. I'm going to close the hearing. At some point in that hearing, maybe we can open up part of it. But I need to dig in, and you all need to dig in to exactly what is the problem with each one of these issues.
So Judge has decided to close the motion to compel hearings on May 14th and May 16th. It seems that really what he wants is to hear argument from both the defense and the state about why, well, the state doesn't have and isn't turning over the items the defense is trying to compel to be turned over. And he wants that to be a very frank discussion outside of the public eye. However, that's not protecting privacy or investigative techniques. It seems to be protecting, I don't know, the FBI?
The FBI!
But if the FBI is not turning things over, I don't know how that needs to be sealed. The state can say, we've asked for these things from the FBI. They haven't turned them over. Getting things from the federal government is not easy. The federal government does not have to cede to the state saying you need to turn it over the same way local law enforcement does. And the prosecution at this point should be telling the judge, we keep asking, they're not giving it to us. So this is what we need the court to do to force it to be turned over. I'm surprised that the state isn't more frustrated that they also don't have this information, but it seems that whatever the defense is asking for is not being turned over to the prosecution at this point. So when the prosecution says they've turned over discovery, they've turned over what's in their actual possession. But that is not everything that exists in this case, because things from other agencies, it seems the FBI, has not been turned over. One of the things I love so much about the Law Nerd community is how incredibly creative you are. I see not only the things you share on social media, but the things you send to me physically that show me that you are crocheting, drawing, painting, writing while you're listening to this podcast and trial streams and all of the other legal coverage that I provide. And if you've ever thought of selling all the amazing things you make, Shopify, today's sponsor, has got you covered. Shopify is where I built the Law Nerd shop literally at like 2 o'clock in the morning with the help of a friend because I was like, we're making a shop, the speed of ADHD. And with the ease of setting it up, I'm not surprised that Shopify's global e-commerce platform powers more than 10% of all e-commerce in the United States. It powers the Law Nerd shop where you guys have been enjoying picking up our new tumblers, but also your favorite nail polish, Rothy's, Brooklinen, and others. Shopify also has the internet's best converting checkout. It's 36% better on average compared to other leading commerce platforms, and they have award-winning customer service that's there to support your success at every step of the way. So it's no wonder that businesses that grow with Shopify. Sign up for a $1 per month trial period at shopify.com/lawnerd. Remember, that's all lowercase. Just go to shopify.com/lawnerd to grow your business no matter what stage you're in. And you'll be hearing this sound soon. Let's get back to today's episode. After the record was made and after the court ruled that the hearings would be sealed, they started talking about their scheduling orders and the fact that the defense was going to be calling witnesses, the prosecution arguing that just disclosing the witnesses isn't enough, that what the prosecution needs is what the witnesses are going to say, reports for the witnesses, and any PowerPoints that the witnesses are going to present, because this prosecutor is not thrilled still about being included in the expert's PowerPoint regarding whether or not the surveys could continue in support of the defense's motion to change venue. So even though the other prosecutor was arguing about whether or not the hearing would be sealed, Bill Thompson takes a moment to make a further record with a whole lot more fire than the prosecution did before. The judge is asking these parties to move forward to hearing because the longer this goes, the more likely it is to push out the trial. And Ann Taylor argued that too. Look, this hearing needs to be public so people know why the defense isn't ready and can't be ready. But the prosecutor has a lot to say about the defense assertion that the state is not turning over information. And we learn more about what the state sees as the problem here.
Judge, I do, for the record, need to clarify the representations of the defense that we are intentionally withholding things that they're entitled to is just utter nonsense.
Wow.
We have strived. We are continuing every week to provide additional discovery. We have more discovery coming. We hope that much of what they felt they had to file a motion to compel on, instead of being patient and wait, their discovery deadline is until September.
The prosecutor straight said, I don't know why they're trying to compel this. We're not even at the discovery deadline. Just wait. I wonder how much of it was compelled a while ago that they still don't have, though, sir.
That we'll have and be able to make that available between now and the hearings on the 14th. And there may very well be little, if anything, we have to fight about. Your Honor also noted there are some things that we simply do not have the power to access. And we have been trying consistently through cooperative efforts, as well as following the process with the federal government. They have been good partners, but they have their own rules to work with.
Mm-hmm.
This isn't the motions for the subpoenas ducis tecum isn't the first TUI process, and the court is aware. We've been pursuing TUI process for all types of information for months.
Oh boy.
So the characterization that we...
For those of you who are like, what are we talking about? TUI process is the extensive process to go through requesting information from the federal government. Again, the states can't just compel the feds to turn things over. So even if the court ordered the prosecution to turn something over and it's not in their possession and it's in the FBI's possession, the state is going through red tape bureaucratic hell to try to get that information from the FBI. It is not like getting things from your local police. Remember when we were covering the Murdaugh case and they had tried to crack into Murdaugh's vehicle and they didn't get it until they were in trial. When you are not a federal prosecutor dealing with the federal government, the TUI process can be extremely difficult, and the government doesn't always have to respond and turn it over. The question is inevitably going to be, but what if it never gets turned over to the prosecution? Then they can't use it all, right? So there might be a motion to exclude down the road, but if the prosecution built their case on evidence or information they got from the FBI and the FBI isn't turning over all of it, it's going to become a large problem for the prosecution, which is probably why they sound so put out. Or they're just really mad that Ann Taylor is putting them on blast, one of the two. Or maybe he's just still mad about the PowerPoint.
You're just consciously withholding information to frustrate the defense is utter nonsense.
Oh, back to
That
nonsense.
is not true. We will provide everything we can that is providable under the rules. If we disagree on something, whether it exists or not, because I can tell you, many of the things that the defendant has tried to itemize, when we talk to our people, they say, that doesn't exist. So, I don't know what we're supposed to do at that point, and we'll flesh it out at a hearing. And it may be that if they have experts who are going to say, well, such and such should exist, we might have to go find experts to say, well, in this case, it doesn't. Or no, we'll see.
Well, that's exactly why I want to close it on the 14th, because we're going to have many arguments, apparently, about issue by issue by issue. And some of that should not be out of it.
Thank you, Your Honor.
So the court has said if we are going to have to go issue by issue, then that is why this hearing is sealed. And you heard the prosecution say the defense is saying, and the defense experts might be saying, remember the defense experts are going to DNA data, not stuff from the probable cause affidavit necessarily, but from other arguments. And the prosecution is saying, we've gone back to people and asked for the information the defense wants, and they say it doesn't exist. So if the defense is telling us it should exist, we might need to have somebody come in and explain to the court why it doesn't exist. So the defense is saying, give us this stuff, and the prosecution is saying, but we can't though. And that is what they are trying to sort out in these hearings.
Your Honor, I want to respond to that, and I could give you particular examples of things.
She got shushed
And
when
it's
she tried
already
to do
been
this earlier.
ordered to be given to us, the cast report, which was a draft that we were promised to have by March 31st. It's May 2nd. We don't have it. So
should.
for the prosecutor to stand up and say that I'm misrepresenting things, he's misrepresenting things.
Oh,
Your
boy.
Honor.
Oh,
That's
You
there.
know what? Let's not go there. I mean, we can sort that out on the 14th.
Well, now everybody's standing
I
up.
read everything. That's what the state was saying. I trust both of you, okay? Your integrity. So I don't want this pointing the fingers back and forth. I don't think it's very helpful. Doesn't really help me. And
Oh boy.
it started at the last hearing, and I really want you all to just tone it down a little bit.
Oh
I mean,
boy.
you can argue all you want, but when it starts to be personal, it's destructive. I mean, you're really, really good lawyers.
They are very
So-
good lawyers.
Let's just focus on the issues.
He's going to take away their
Your
coffee.
Honor, we're happy to. And when we get the cast report, we'll disclose it. If we do not have it, we are not withholding.
How do you not have
As
it?
simple as
I
that.
read that last night. Okay. I'm very prepared about what the issues are, okay, about the discovery. And that's why I want to be able to hear from both sides, okay, what is the problem with this? What do we need to go forward? And I'm going to try and help that. And I expect that both of you do the same.
Judge seems annoyed with the level of zealous advocacy from these attorneys. I still think the prosecutor is upset about being included in the PowerPoint. I think Ann Taylor is frustrated because the media and the public is pinning on her the fact that this trial may keep getting pushed out beyond the summer of 2025. And she is like, I am just trying to do my job, which I cannot do if I don't have the discovery. And the defense has said, we're not at the discovery cutoff yet, and I can't give you what I physically do not have. And the defense is saying, but you should have it. And that is why the court wants to close this hearing so they can talk about the particulars, so that the prosecutor can say, I have spoken to these individuals and they have said these things about us not having it, and get really into the weeds with that information. Why that needs to be sealed, I don't know. Judge thinks it does, but now he's asking everybody to dial it down and basically saying this level of hyperbole is unhelpful. But Ann Taylor is frustrated, and it seems that the prosecution is frustrated. And because there are limited things in the public eye in this case, it gains more attention than if everything was public. At the end of the May 2nd hearing, defense attorney Ann Taylor was asking to set standing hearings in this case so they could start moving through things a little bit more quickly without scrambling to find time on the court schedule. Not surprisingly, Judge said his calendar is quite full. His docket is quite full, and he has a number of jury trials coming up, but they were working on what day they would set standing hearings twice a month. He said, maybe as we're getting through discovery, we will do that and then see where we go from there. He seems anxious to get the case moving, but then hasn't decided on some key issues to allow the attorneys to move forward. Judge also addressed the issue of the defendant's alibi. And of course, the state again pushed back on the defense's notice of alibi when they gave a little bit more information about Bryan Kohberger being out driving at night to look at the stars and the moon and take pictures of it, as he sometimes does. Though she didn't say he was taking pictures that evening, she did talk about him being in the area of Wawawi State Park and not driving in the direction of the victim's home. The prosecution pushed back and said that that is still insufficient notice of alibi, and that's not really an alibi at all. And the only witness is a cell phone tower expert who will rebut where the cell phone was, but that is not notice that the defendant was at another place or with another person at the time these crimes were committed. So essentially, the full alibi notice was a extended version of the last alibi notice, which is sometimes he goes for drives late at night. The court asked the attorneys if they needed to have a hearing on the alibi notice, and it looks like at some point there will be a hearing about that alibi notice, but everybody's quite busy with these sealed hearings coming up. And of course, you heard in that hearing that the court sealed the motion to compel hearings on May 14th and 16th. Those will not be public. The press will not be allowed. We will probably not know what is decided at those hearings because it will all be under seal. And with that, we are all caught up with what's going on in Idaho, and I'm sure we will see other flurries of activity, because what is still pending that we know is, well, that hearing on the notice of alibi, but also we have not even gotten into the briefing on the motion for change of venue. We know that the surveys were allowed to continue for the defense to try to find where else in Idaho they might want to have this trial, maybe in the summer of 2025. So we won't know what the court's going to do there until those briefs are filed. And I imagine there will probably be more than one hearing on it before Judge takes it under submission and makes an order later. But we haven't even gotten to that briefing yet. And we will start to see that later because that motion had gotten pushed off because the surveys were allowed to continue. And that briefing got set out quite a ways because the court set the motion for change of venue on June 27th, 2024 at 10 a.m. That will be publicly available. Will we still be in the Karen Read trial on June 27th? I don't know, but I will keep you up to date on the briefing on the podcast. The defense motion for change of venue, their opening brief is due May 31st. The opposition from the state is due June 14th. The defense reply is due June 20th. So June will be quite busy, but for at least part of June, we will still be in the Karen Read trial. And then I'll be at VidCon. But that's all right, because I can stream from anywhere, can't I? So with that, thank you for being here. Thank you for being a Lawnerd. This is the Emily Show podcast. We need to wrap it up. If you don't want to miss live trial coverage of the Karen Read case, or any case, make sure to download the Law Nerd app at lawnerdapp.com. And with that, may your Wi-Fi be strong, may your toilet paper be plentiful, may your bidet be warm, may your family be well, and may the odds be ever in your favor. You can stay up to date with everything I'm covering on our free iOS and Android app at lawnerdapp.com, or search your app store for Law Nerd. And you can also follow me on social media at the Emily D. Baker. Remember, I stream on YouTube on Tuesdays and Thursdays. I recap all of that for you in quick bits on Monday. And of course, the Emily Show drops on Wednesdays. Thanks for being a Law Nerd.